morning, everyone. This is Jennifer Arsenian. I'm a Senior Program Manager here at the National Council of Juvenile Family Court Judges. I just wanted to welcome everyone to this webinar. We're very excited to have you here. This is Power Within the Paper, Court Responses to Enhance Compliance and Enforcement of Civil Protection Orders. We have here today two fabulous presenters. I have the pleasure of introducing Honorable Berryl Anderson. She's the Chief Judge from DeKalb County Magistrate Court, which is the mentor court, and she'll introduce herself more and tell you more about what they do there. And Darren Mitchell, who is an attorney and consultant with the National Council on many projects, one of them being our Civil Protection Order project, which is what this particular webinar is under. So through funding with the Office of Violence Against Women, U.S. Department of Justice, we're able to provide this webinar to you. It is part of our Civil Protection Order Guide Technical Assistance Project, where we provide information, training, and educational opportunities like today to the field that sole purpose is to improve practices around civil protection order system for petitioners, survivors, and their children. So we welcome you today. Please feel free to contact us if we can provide any information or resources. Our website address is at the end of this webinar. And so I'm going to turn it over to the presenters to get started today. So thank you.
Good afternoon, everyone. My name is Berryl Anderson, Chief Magistrate Judge here in DeKalb County Magistrate Court, DeKalb County, Georgia. Portion of the City of Atlanta is located in DeKalb County. We have a civil protection order compliance calendar, and I'll be sharing some of the information about that calendar with you today. And I also have on the line with me Darren.
Yes, hi. This is Darren Mitchell, and as Jennifer said, I'm a consultant to the National Council of Juvenile and Family Court Judges. I'm also a consultant to several other national technical assistance providers focusing on issues around, of course, civil protection orders, but also firearms and domestic violence and decision-making by family courts when there is domestic violence within the family. So pleased that you can join us, and we're looking forward to talking about a lot of different aspects of the enforcement and ensuring compliance with civil protection orders.
So we'd like to learn who's on the line. So we'd like to put up a poll and find out some of the different disciplines that are on the line with us and able to join us this afternoon. Okay, we'll keep the poll open for just another minute or so. All right, it looks like we have a variety of individuals. We have a few judges on the line, some members of law enforcement, some attorneys, some individuals who work with batterer intervention programs, in the civil justice system, clerks, custody evaluators, some neutrals, some judges, and individuals who work with coordinated community response, dating violence, and sexual assault programs, some immigrant organizations. I want to thank you all for joining us, and we should have a very engaging conversation because we have such a great representation of individuals on the line. So I want to tell you what you can expect as a result of the program this afternoon. Some of our learning objectives are that as a result of this webinar, participants will be better able to discuss ways to promote victim safety and batterer accountability by prioritizing civil protection order enforcement. You will also be better able to identify and take advantage of opportunities within the civil protective order process to better prevent and respond to abusers' access to firearms. And lastly, describe the role of compliance that compliance hearings play in enhancing the system's response to violations.
So I'm going to get us started by talking a little bit about the first aspect of all this. So of course our focus today is on enforcement and monitoring compliance with civil protection orders that have been issued. But we all know that a key step in ensuring that the order is going to be readily enforced by law enforcement, prosecutors, courts, is to make sure that those orders have certain qualities and characteristics to them, specificity and clarity and some other aspects too. So we always start conversations about enforcement by focusing on issuance. And the way we're going to talk about the issuance step this afternoon is by first talking about how courts, through information provided to them, either directly by litigants or through other stakeholders in the system, need specific information in order to make their orders enforceable. So we're going to talk a little bit about how courts can go about and how others can help courts go about getting specific information. Then Judge Anderson is going to talk about some aspects of the order themselves, what makes for a readily enforceable civil protection order. So let's start off by talking about getting the information. First of all, what sorts of information is necessary for a court to issue an order that's clear and specific enough to be readily enforced and to facilitate the enforcement of the order? Well, there are lots of aspects of that kind of information. On a very logistical level, the respondent's identifying information can be critical, especially as orders, we try to get orders into databases, both databases at the state, tribal level, and the national databases. Identifying information is critical for that. And in addition, of course, when law enforcement responds or others respond, knowing that this is the respondent on an order, you need to establish that, of course, for enforcement. We also want to talk a little bit about getting information around lethality and dangerousness of the respondent and what's going on in this particular case. So we're going to spend a little time talking about some tools and methods for getting that information to the court. In addition, specifying what the abusive acts are, so both the court can find that the person seeking the order has met any legal requirements to issue the order, but also so that the relief granted in the order can be specific and responsive to those abusive acts is another critical part of the getting the information step. Finally, as a thread throughout today's conversation, we're going to be talking about ways to limit respondents' access to firearms when the civil protection order renders them someone who's prohibited from having access to guns. And so we're going to talk a little bit about how to get specific information about respondents' access to guns so the order can then be clear and specific and enforceable in that regard. The respondents' identifying information piece there are some obvious paths to getting that information, and some of this is already built into many of your forms and petitions. In some instances, this could be strengthened, but it's clear that petitions should have as many different ways for the petitioner to provide the numerical identifiers, especially of the respondent, the better. And it may very well be that the petitioner doesn't know them all. She may not know a date of birth. She may not know the Social Security number. But others potentially can have that information, including law enforcement officers responding to a domestic violence incident can gather that information, of course, as part of their domestic incident reporting. That all needs to get to the court somehow. Advocates, of course, can work with survivors to try to figure out that information and to let survivors know exactly what's needed to report issuance of the order and getting the orders into databases. So advocates should be focused on that as well. In their assistance. I already mentioned domestic violence incident reports. Finally, community supervision officers, so probation parole officers who sometimes have a role to play in the civil protection order process, and court resource coordinators, which many courts have. Judge Anderson's court does as well. A court staff member who's responsible for many aspects of administering the civil protection order system. They can be a source for information about respondents' information. And of course, this also applies to service of process. Getting information about where the respondent lives and works can be critical to getting the order actually served. And it is a similar set of information you may want, and similar folks can be working on getting that information. Wanted to point out a couple of examples of forms that can be particularly effective in getting this kind of information. So in Ohio, there's a sort of accessory form, a complementary form, this Form 10A, the Protection Order Notice to NCIC. NCIC is the National Criminal Information Center, FBI's national center where they can collect and maintain and allow access to by law enforcement information about protection orders and other things as well. This is a form that Ohio developed to ensure that entry into NCIC would be facilitated by collecting, among other things, numerical identifiers about the respondent, also whether the person who is restrained by the order, the respondent, whether that order is going to limit that person's access to firearms. So there are a couple of questions around that. Check out this Form 10A that Ohio uses. I think it's a great model for getting information to courts. In addition to that, we have an example of the first page of Project Passport, which is a similar front page used by many states around the country many years ago. I think it may be 10 or 15 years ago this started. It's been a while. There was an effort to get folks to develop front pages that would be recognizable by law enforcement and others in orders that were brought from out of state, out of the tribe. One of the things that was built into this recognizable first page were respondent numerical identifiers. So whether or not your state has the Project Passport model, this information should be readily available on the first page of the order as a best practice. Now let's shift over and talk about lethality and dangerousness a little bit. And there are several ways for the court to become aware that a particular respondent is particularly dangerous, presents a threat of lethal violence in a case. Of course, advocates have a strong role to play in all of this, and in fact, work by advocates to help talk to survivors as they safety plan, as they decide on options together, to gather information about what is particularly threatening about this respondent so that can be brought to the court's attention if the petitioner decides she wants that information to be shared with the court. One way to facilitate that happening is in jurisdictions that use the lethality assessment program, actually, model, which is run out of the Maryland Network Against Domestic Violence, which involves law enforcement administering a screen, a lethality screen, to every victim in a call, asking questions. This is an example of the screen, asking questions about lethality factors that have been determined by research. This is research done by Dr. Jacqueline Campbell at Johns Hopkins School of Nursing, for those of you who know her, asking questions that, that research has shown indicate a higher level of lethality. For folks who screen high in terms of lethality presented by their abuser, there is a referral made to local domestic violence programs. The local domestic violence program gets this information, and that process of figuring out what the lethality risks are and whether to ask the court for some relief, some protection, can begin with the survivor. I mentioned resource coordinators earlier. They too can help collect data around dangerous and lethality. And they may have access to criminal history of the abuser that can help with that information. They can sometimes interview folks, get this information. So another potential vehicle. Probation, pretrial services as well, of course. I also wanted to point out a couple of bench cards and associated forms that the Center for Court Innovation has put together, and others have done similar things, but the CCI ones are particularly useful. And I'm going to show you a copy of that right now. This is a guide for specifically petitioners. There are corresponding guides for judges, for the bench, as a bench card, in deciding what to do around the risk presented by a particular respondent. And so what this particular guide does, which has been translated into Chinese and maybe other languages as well, goes through the risk factors that I just mentioned and helps, working with advocates, petitioners think about these risk factors, whether they affect them, and then how they may want to describe that in their petition for a civil protection order, and what relief they may want to seek based on those particular risk factors. So it's a very nice tool for facilitating a conversation, especially with an advocate, around what to reveal to the court, how to reveal it to the court, and what to ask for in response. These forms are available on the Center for Court Innovation website. Definitely look for it, and you can download them yourselves. You can also, if you're a judicial officer or work for a court, you can get the corresponding bench guide as well. Okay, specific acts I mentioned earlier. We would want to know the specific acts of abuse. And I'm talking about this in part because having worked in this area for almost 20 years now, having had lots of occasion to look at civil protection order petitions from around the country, I have to say that in many instances, those forms do not facilitate getting very helpful, specific information to the court. They could really use a revision. So I want to show you a couple that are more specific and provide a greater likelihood, especially that self-represented folks will get information to the court that's helpful in determining what's been going on and what potentially can be done in response. The first one is from Oregon State. This is on their petition. For each incident of abuse that the petitioner describes, there's this space which has prompts for the survivor to answer information that the court would find helpful in making its findings and in making its determinations about what relief to present. In addition, Washington State has some very specific prompting questions about abuse towards the petitioner, threats, and other forms of abuse, violence and threats towards the kids, stalking behavior. So having something like this, whether a survivor is sitting down with an advocate or filling these things out on her own, can be very helpful in generating, in helping facilitate her thinking and providing the court with information that will be truly helpful in decision-making and around issuing the order and relief. So we highly commend these types of approaches to you all. I'm going to close out by talking about, we're going to spend some time later talking about enforcement of firearm prohibitions, but let's start by talking about getting that information. The key thing for courts to understand in issuing orders is what the respondent's access to firearms looks like. And specifically, getting information about the types of guns, where they are, and how many there are can be critical to having an order that's specific and thus more readily enforced by law enforcement because they know where and what to look for. So a couple of examples of what this could be in your jurisdiction. The state of Washington, which completely revamped its approach to firearms in domestic violence cases and civil protection order cases, developed a series of really excellent forms, including this voluntary, optional form that petitioners can fill out regarding respondents' possession and access to firearms. As you can see, as I said, it's an optional form. You can say that your respondent, your abuser, has access to guns. You're afraid. You'd like them taken away. Here's what they are. Here's how many there are, et cetera, et cetera. Very useful voluntary form. The SAFE tool, which I'm showing now a page of, was developed by the Battered Women's Justice Project to assist advocates who are safety planning and helping survivors discuss their options around firearms, enables survivors to have a conversation with an advocate about what specific guns are. So using pictures and a whole series of questions that I'm not showing here, the advocate and survivor can work together to paint a clearer picture of what respondents' access to firearms looks like and thus ask for very specific relief from the court. I'm going to turn it over now to Judge Anderson to carry on around issuance.
One other thing I'd like to add, Darren, as it relates to the firearms and this wonderful document created by the Battered Women's Justice Project, is that it also saves time in just allowing the victims to just circle or draw an arrow towards the type of weapon. Many victims are not familiar with what the difference between a long gun, a rifle, a handgun, a semi-automatic, or an automatic. And so to the extent that you can have something to assist victims in identifying the type of weapon, it is very helpful. It has been actually very helpful here in DeKalb in our process with when victims have spoken with judges during the ex parte hearings. It has been very helpful in determining what type of weapon a respondent possesses and exactly where the weapon is located. We had an incident where the victim was very clearly able to articulate that the weapon was located in the nightstand on the right side of the bed, under a book. So she was very clear as to where that firearm was. And I also want to point out that retrieving firearms is not also an issue of safety for the victims, but it's also an issue of safety for law enforcement when they go in and try to enforce these orders. So I want to move on and talk about what is necessary in helping judges issue protective orders. It is very helpful to make sure that the orders are clear, that they're specific, that there is actually a jurisdictional basis for the court ordering whatever relief is being required or being requested, that the orders are able to be given full faith and credit from a compliance standpoint, and also there needs to be some discussion and explanation of how victims can seek enforcement in the event that there are issues with enforcement of the order. Judges, you need to make sure that the orders are specific and detailed and explaining exactly what behavior is prohibited. I know that a lot of the forms in many jurisdictions across the country are very general in nature, but if you're a judge that's hearing an ex parte proceeding, or you're hearing what we like to call a 12-month order, an order that extends an ex parte order, if there's some specific conduct that is not specifically spelled out in your standard orders, then write it in there. Just be very clear about that so that both the victim and the respondent are aware of what types of behavior is being prohibited. Any restrictive communication, if you need, now technology is a huge issue, so you need to make sure that you remember to talk about texting and emailing and electronic surveillance. As it relates to firearms, you want to be clear about making sure that the firearms are being surrendered, and you should have a process in place as it relates to surrendering those firearms. And I realize that that resources are different in every jurisdiction, but to the extent that you can have a process in place, perhaps a coordinated community response to talk with law enforcement in your jurisdiction and make sure that there's a process for having those firearms surrendered, having those firearms stored, and then holding either a compliance hearing or some sort of proof and affidavit from law enforcement ensuring that any known firearms have been surrendered. If there are some issues as it relates to visitation and access to the children, you want to make sure that that is very clear. And I want to just go out and encourage you that if there's some serious allegations of violence and stalking and there are threats to the children, judges, you may want to consider no visitation from the outset, but then look towards taking steps to make, if you can show that there has been some compliance on the part of the respondent, to get to a point where you have graduated visitation or supervised visitation or supervised exchange. Just something for you to think about. And again, I know that if your community is rich with resources, it's easier to do that than in those jurisdictions where you have limited resources. If there's something else that you're going to fill in the other category, you want to be very specific and make sure that it is specific to the cases that you're hearing. And all of these cases are different. You can't really take a cookie cutter approach to crafting an order. Each victim presents with different needs. And while some terms of the orders may be general and may apply to everyone, there are some other matters that are very, very specific. And to the extent that you can use the other category to address it, then please consider doing that. Again, they need to be clear, very clear about what the court's order says and what the expectations are. It should be explained to both the respondent and the petitioner. It really helps to have that in open court and to repeat it. It's important to have it as part of the court colloquy or some of the instructions of the court. And it's something about repetition, seeing it written in the order, but also hearing what's in the order reinforced by the judge Often, it really helps to be more than once enforced in court in front of the parties can be helpful. There's some information and materials at this website that you may be able to view, and for resource purposes, maybe you can visit it later. Cook County, Chicago Circuit Court, www.cookcountycourt.org. About the court, you may want to take a look at this information whenever you have some time. Jurisdictional basis. You want to make sure that that you actually have jurisdiction over the case that's before you, so that the case is that the petitioner is able to get full faith and credit in the event that you have to have another jurisdiction involved. For the judges on the call, I'd like to call your attention to a wonderful product by the National Council of Family and Juvenile Court Judges. It is a document that you can access on their website. Again, that's National Council of Family and Juvenile Court Judges. It is called a Passport to Safety. In this Passport to Safety is some very valuable information and bench cards for you as a court in trying to determine what to do if a victim comes before your court with a protective order from another state. Talks in detail and has some very specific step-by-step instructions about granting full faith and credit to those orders, and how you are to handle it, the orders if you are the issuing court, how to handle those issues if you happen to be the enforcing court. It also deals with issues involving the PKPA, the Parental Kidnapping Prevention Act, and the Uniform Child Custody Jurisdiction Act, UCCJA. It also has some information about firearms and information about the Brady Act and how to facilitate enforcement of getting access to the weapons and returning those weapons. So I encourage you, if you don't have this resource, it's a very valuable resource. It's out there. You can get it online at the National Council for Family and Juvenile Court Judges on their website. Or if you're like me, I'm a little old-fashioned. I like hard copies, and it's an actual glossy bench card that you can put in your toolkit. And I assure you, if you hear these cases, you'll be able to refer to it on a regular basis. So the full faith and credit and the actual overview of federal law as it relates to granting full faith and credit to protective orders comes from the Violence Against Women Act, VAWA for short, and it mandates that protection be given, that all orders be given full faith and credit. It was signed into law on September 13th in 1994, amended in 2000, and then amended again in 2005. The full faith and credit also, it applies to states, Indian tribes, and territories, and it says that all courts must enforce valid protective orders. And what do you mean, when you say valid protection order? It has to be an order that was issued by a court that had jurisdiction, and that's a court that had jurisdiction to hear these types of cases. Equally important is that the respondent has had notice and an opportunity to be heard. Now, there's no requirement that the respondent actually have attended the hearing, but the respondent, the court has to show that and document that the respondent had notice of the court proceeding and had an opportunity to be heard. This can be whether you're talking about a protection order, can be a temporary order. In Georgia, it's called an ex parte order, and the orders are valid for 30 days, and you need to have what we call a final order hearing within 30 days. So a protection order is defined as either the temporary order or a final order in a civil protective order or stalking case. We have two bases for protective orders in Georgia, either under the stalking statute or the family violence statute. Protective orders protection orders can be either civil or criminal. If there is a stay-away provision in a criminal matter, that can be equally enforced. And any other type of injunction or restraining order filed by petition or motion, and most of them are based on, for purposes of preventing violence, threatening acts, or harassment of the petitioner. And many orders, especially in Georgia, we're fortunate they provide very broad relief. That broad relief can include, in addition to preventing the harassing, stalking, or violent behavior, also covers child support, child custody. It allows for visitation. We have the benefit of having a supervised visitation, safe exchange of visitation here in DeKalb County. Some communities have that. It also covers any other types of remedies or relief in the order. Again, just to reiterate, the order has to be, in order for it to be valid, the issuing court has to have had personal and subject matter jurisdiction, and the respondent must have had to have had reasonable notice and an opportunity to be heard. Let's try to move things along here. Here's a sample before you of an order of protection. It also looks like it could be used for an amended order of protection. Requires information of both parties. Again, that identifying information, date of birth of the petitioner here, but it also has distinguishing features about the respondent. Some of that is not really clear. It's got a caution box here so that you can determine whether or not there was a weapon used. It clearly states in the language of the order that the court has jurisdiction over the parties and the subject matter, and explains that the respondent was given reasonable notice and an opportunity to be heard. It looks like a very standard form, and I'm sure many of your forms have this information here. And down at the bottom, it states that this order is to be given full faith and credit, and regardless of the jurisdiction that the petitioner is seeking to have it enforced in, not just the issuing state, but anywhere where the petitioner may go for assistance. And at this time, I will turn it over to Darren.
Thank you. And actually, so this last form that Judge Anderson just showed, the main purpose in showing this is actually the project passport form that I mentioned earlier. And just to point out that this jurisdictional basis sometimes is not found on court orders. And that can be problematic in terms of future enforcement, especially court enforcement. So it's really a call, that box that's been pulled out of the form that says the court hereby finds that it has jurisdiction, to ensure that your orders have that kind of language. And that's a little bit of a segue into the next piece. I'm just going to speak for a couple of minutes to emphasize interjurisdictional enforcement of custody provisions and other child-related relief in protection orders. It's a little different than it is for the stuff that Judge Anderson talked around enforcement, especially interstate enforcement. On the child custody side, there are a couple of more considerations, and this will be a brief overview of a lot of information. If you need more assistance, get in touch with us. Or the most beneficial thing to do would be to contact the organization listed on the bottom of the slide, the Legal Resource Center on Violence Against Women, which specializes in this topic. But just as an overview, you have to have a jurisdictional basis under the UCCJEA, that statute, which is a uniform law that all the states and some of the tribes have enacted, that guides interstate enforcement of custody provisions, both in protection orders and standalone custody provisions. You have to have a jurisdictional basis to get interstate enforcement. Most likely, if you're entering a custody provision as part of a civil protection order, that is going to fall under the temporary emergency jurisdiction provision of the UCCJEA. In an emergency, a court is able to enter a temporary emergency custody determination, even if it's not otherwise allowed to. In most instances, that's if there's another home state which would have preferred jurisdiction. The key here is if you're a court that's entering this kind, first of all, if you're an advocate, attorney, trying to assist someone getting a custody order as part of a civil protection order, it's important to understand that that provision exists, and people who have fled from one state to another and haven't been there very long can still get a temporary custody order in that refuge state under this provision. But in doing so, you would want to ask the court to indicate that there is a jurisdictional basis for entering the custody order, because that will enable it to be enforced back in the original state and elsewhere around the country. There may be judicial communication required under the statute if there's already an ongoing custody case in another jurisdiction and someone comes for safety to your jurisdiction and the court issues a civil protection order that includes a custody provision, the court in your refuge state must communicate back with that original court about the duration of the order and what's going to happen next. Therefore, it's really important to put court contact information on all of your orders so that communication can take place. And as I mentioned, please do call the Legal Resource Center if you have questions around this issue. I want to show you one quick example here of a way that this can be approached. And in California, it's not clear. There we go. In California, there is a portion of a child custody visitation order that enables all of these things to be put on the face of the order, including the jurisdictional basis and information about where the parents lived and things like that, that enable a court to have jurisdiction and show that it had jurisdiction over a child custody decision. This particular form is attached to the civil protection order in California to clarify the child custody jurisdictional aspect of that order. Great model for folks to clarify that particular issue, which can be very confusing. I'm going to turn it back to Judge Anderson, who's going to continue on around issuing enforceable orders.
All right, back to issuing enforceable orders. And an explanation of how to seek enforcement. Strategies, you can talk about that. As I said, it's really helpful when you're at the hearing to have the parties before you and talk about the fact that the order is enforceable and that the court will take steps to make sure that the order will be enforced. A court resource, it can be a staff person on our staff here in DeKalb. We have a compliance officer who's charged with making sure that respondents are complying with the court order, obviously by not violating the order and contacting the petitioner, making sure that all firearms have been surrendered, and ensuring in accordance with Georgia law that the respondents are signing up for and participating and taking the state-mandated, we call them FVIP classes, that's short for Family Violence Intervention Program classes. They're 24-week classes that are mandated by the court. So the compliance officer is charged with making sure that all of those things are happening. It is really important from my perspective, I believe in our court's perspective, that the victim's voice is in the room. Our compliance hearings and enforceability don't directly have any, we don't directly have any contact with the petitioner. And we're fortunate here in DeKalb that the advocate can bring any violations or any information that the court needs to hear about, that an advocate is still involved and can bring that information either to our compliance officer or also to our domestic violence case coordinator. It's also it's important to make sure that you have information in brochures, to the extent that you're able to have information online about strategies to ensure that the protective orders are being enforced. Again, I just can't say enough about the role of the advocates in our community anyway with making sure that the victims are kept safe long after the protective order has been put in place. And while none of us can ensure safety, we can be mindful of practices that are signs that a victim may be in danger. So it is important that the law enforcement has a process in place for dealing with civil protective orders and making sure that they're enforced. We need to ensure that, as we said earlier, the interjurisdictional enforcement of child custody provisions. You need to have contempt procedures in place if they're allowed in your jurisdiction. And what we have found most beneficial is having actual compliance hearings on a regular basis. We have compliance hearings every other week, where the respondents are ordered to come back to court to ensure that they are complying with all of the terms of the protective order. It's important to make sure that you communicate with law enforcement, as I said, so that they are aware of what the court's practice is as it relates to violations of orders. You can conduct contempt proceedings if that's allowable in your jurisdiction. You want to make sure there's compliance with firearms, child custody, and any other relief that has been ordered with the court. I cannot emphasize enough how important it is to have a coordinated community response around how protective orders are handled in your jurisdiction. We have the good fortune of having here in DeKalb County, as I said, a compliance officer and a domestic violence coordinator, but we communicate regularly with law enforcement. We meet regularly with them. We train our law enforcement officers on issues surrounding protective orders, serving those protective orders, and a couple of years ago, as a result of coming together with all law enforcement, our local DeKalb County Sheriff's Office, who is charged with serving the civil protective orders, figured out a way that the police department, law enforcement, can actually assist them on the ground in real time in helping serve protective orders in those cases where law enforcement is called to a location and an order has not been served. A victim can let the police officer know that. The police department can get the sheriff on the line, and they can actually serve the respondent with the protective order on scene and take steps to make sure that the victim is safe and remove the respondent from, or evict the respondent from the location. But that took some time. It took some coordination, and it required everyone sitting down at the table and talking, understanding with no judgment, with no egos, the various roles that we have, and trying to figure out how we can create a safer community. It's not just about making sure that the court's order is enforced. That is important, but in order to create safer communities, we need to make sure that everybody has a seat at the table and that everybody understands that they have a role in helping us to create safer communities by enforcing these orders. So these are civil cases, and we want to make sure that that law enforcement has a standard response and make sure that orders get served. One thing that we discourage is having law enforcement arrive on the scene and try to give legal advice. That can be dangerous. And so to the extent that we are able to, we train law enforcement. We try to make sure that they have information that they can give to victims on the scene to refer them to an advocate for safety planning and to make sure that they have someone that can talk to them about resources that are available and to assist them with not just the criminal aspect of matters, but also to refer them for protective order if that is something that, that a victim would like to have. Contempt proceedings. There are a couple of different types of contempt proceedings, and victims have options. And I am a former legal aid attorney, and I learned a long time ago that it is really important that we respect victims' wishes and respect victim autonomy. And so victims need to know what their options are. And so there's a contempt process, which may be available in many of your jurisdictions. It's certainly available here in DeKalb County, and also the criminal prosecution. But it really, so there are really two courses that can be pursued here. I do want to say that you have to be mindful of what is available in your jurisdiction and make sure that you're mindful of what the laws are. There's a recent law in Georgia that sort of limits, while you can pursue a contempt matter and a criminal prosecution, pursuing a contempt matter might create a double jeopardy issue down the road if there's a criminal prosecution. And so you need to make sure that victims are getting some good legal advice. That's where the attorney's on the line, where the attorneys can be helpful in advising them on, and advocates advising them of what course of action to pursue. As judges, if there is a civil contempt here in Georgia, we sit and hear these cases as Superior Court judges. The maximum penalty that can be imposed is 20 days in jail. So we want to make sure that victims know and have an opportunity to have a voice in what is pursued in their jurisdiction. So what is contempt? And, the court has inherent power to enforce its own orders, and that you can deal with contempt in a number of ways. As I just said, that the court has the authority to have someone taken into custody for a period of 20 days. In some instances, the court can modify an order, amend an order, but it's ultimately up to the court to decide how it wants to handle any violations of its orders. Fortunately, any violation of a protective order in Georgia is a criminal matter, and depending on the nature of the conduct, it can be either a misdemeanor, punishable by up to 1 year in jail, or it can be a felony charge, which is punishable for violating a protective order if it is dangerous behavior, an aggravated stalking charge, and the penalty is from 1 to 10 years in prison for violating that order. So why would a victim want to pursue civil contempt or any type of contempt rather than criminal prosecution? Is that the process can be faster, and I will say that's not always a given, but it just depends on your jurisdictions. It may be faster in your jurisdiction, it may be slower. In some instances, victims just don't want the respondents locked up. They don't want them locked up. They want the child support issue enforced, or whatever term of the orders has been violated. They want that enforced by the court. And so, again, I would say that it's up to the victim. You want to make sure that you hear them, that their voice is heard. And the third bullet point here is that it can be initiated by the victim without awaiting an arrest or filing charges. There is a process that has to be followed regarding notice and an opportunity to be heard and service. And there can be a bit of a challenge if the petitioner does not know where to find and have the respondent served in a contempt action. So that can be one challenge. So the difference between the civil and criminal contempt, the objective is to aid the complainant by coercing future compliance with the terms of the court order. It can be remedial in nature, and it's appropriate when a defendant has failed or refused to do something that the defendant, or in our case, I'll say that the respondent has been ordered to do. And it's something that the court can enforce, and at the request of the respondent, something that the court can enforce. Criminal contempt, the objective is to vindicate the authority of the court by punishing the wrongdoer for violating a court order. It is punitive in nature and appropriate when the defendant has done something that the defendant was ordered not to do. You may want to, certainly if there's been contact and it's not something that's a monetary violation, you may want to consider going the contempt route. But again, I'd like to say it's something that should be started by the petitioner or the victim in the case. In criminal contempt, violation of provisions prohibiting contact, harassment, assault, again, as I said earlier, I think that's when you may want to consider having a respondent taken into custody, or if there's been a destruction of property in violation of the court order. Civil contempt, you may want to consider as I said earlier, if it's been a monetary violation, failure to return property or surrender keys, having the children, violating the visitation or custody order by holding on to the children too long, we're not returning them when they're supposed to. Certainly failure to relinquish firearms to me is dangerous, and you may want to, I might also look at criminal contempt for that. One thing that you cannot do in Georgia is if visitation is part of the order, the court cannot force a respondent to exercise visitation. But if there are violations around returning the child at the appropriate time, then that's something that can certainly be considered to be a violation of the order. So some suggested practices enhancing access to the contempt process for victims is that, as I said, it can expedite. It would be great to have expedited contempt proceedings for civil protective orders. That's something that we've been considering here in DeKalb, but it really is a matter of having, it doesn't just affect the court to have a standalone contempt proceeding. We have to make sure that advocates are available and to make sure that it is a process that works for everyone. We are a little bit space challenging here in DeKalb, but that is something that we're looking towards implementing in the future, is to have some expedited standalone contempt proceedings in protective order cases. I really think that's the best practice. Some states have this, Connecticut and Illinois. It is really important to train advocates, civil attorneys, and others on the contempt process, and to develop a user-friendly, understandable contempt petition. I know that some of the court's forms can be a bit challenging for petitioners to just navigate on their own. We need to be mindful, if you're a court, to be mindful to make sure that the forms are in plain language, fourth grade literacy level is helpful, and to make sure that forms are available to everyone in multiple languages. If the forms are not available in multiple languages, to make sure that that all of the petitioners or victims in your jurisdiction have access to perhaps a language line, or best practices would be someone who is an interpreter and can speak their language, but at the very least have someone available on language line to assist petitioners or victims. It's nice to develop a litigant guide explaining contempt in any type of self-help forms or any forms that may have been developed by the advocacy agency in your jurisdiction, or perhaps a legal aid office in your jurisdiction, would be helpful to provide to victims. It is really important that from the court's perspective that victims know that you have an open door and that they're always able to come back and have access to the court at any time. It is always helpful, and I think it really expedites the process when victims have access to an advocate to help them navigate this court process. And while I would be the first to say in DeKalb that we do not have a perfect process, we have a process that I think is much improved since I became the chief about 9 years ago. At that time, I did a walkthrough of our temporary protective order process, and it really gave me an opportunity to see where some of the pitfalls were and challenges were in our temporary protective order process for victims. And a lot has changed over that time to make sure that the court is more open and more accessible, and that it is a lot easier process to navigate for victims who may be going through a very, very difficult time. And so to the extent that all of you can work collaboratively with your courts and victims, advocates, law enforcement, that you can come together to take a look at your process, I encourage you to do that. And it's one of those things that's ever evolving. We're always taking a look at our process and trying to make it easier to navigate, trying to make it safer to navigate, more accessible, and calling individuals to the table and having meetings with them and letting them know about our process and letting them know how they can assist the court in making this process easier for everyone and making our community safer. And with that, I'll turn it over to Darren.
Thank you. So we've talked about some general enforcement issues in contempt. We have a couple of more specific topics around enforcement that we're going to talk about. And then we're going to close out by talking about compliance review hearings, with which Judge Anderson has a lot of experience, and we're going to share some thoughts about that. The two specific topics we're going to talk about are firearms and then the enforcement of child-related relief. So let's start with firearms. And to help you understand how we, when I'm working with the National Council with my colleagues, think about addressing firearms in the civil protection order context, we often think about the overall process and where the points of intervention are. Places where we can either learn more about respondents' access to guns or do something about that by getting the guns. And so we roughly will look at a process as one in which there's the initial information gathering by the petitioner around what can be done, what her options are for getting relief around guns, getting that information to the court, issuing clear and enforceable surrender orders, which we've talked about a little bit, ensuring that the parties understand what their obligations are, and for the respondent who's ordered to surrender guns, what are the specific steps that need to be taken to carry that out and then prove it to the court. We look at service of process as a specific opportunity that not enough jurisdictions take advantage of to either learn about guns or take guns away, and we have some practices at the service stage that we think are very effective. What we're going to focus on today is the step of monitoring compliance, which is, okay, you now have an order out, person's supposed to surrender guns. Are they, have they, are all the guns surrendered, things like that. We're going to focus on that in just a second. The last is there's always the return process. The order ends, the respondent wants his guns back. What does that look like? How's it done safely and effectively? But we're going to focus, as I said, on monitoring compliance. And to the extent you want more information about any of these other steps or addressing guns in the criminal context, I suggest that you check out NCJFCJ's website, ncjfcj.org, and look up the firearms material. There are a series of webinars and other information around these various steps that are available to you. You can always get in touch with us too, and we'll get it out to you. But on monitoring compliance, these are what we think, based on working with jurisdictions around the country who have figured out effective ways to figure out whether people are complying with their gun surrender orders, that they've put into place that seem to be working. One is, as we said several times, you need clear and specific orders with specific deadlines to have an effective compliance system. You need very specific instructions that are quite understandable by the litigants. Where you turn in the guns, which agency, to whom at the agency. Do you lock the guns in your trunk with ammunition separate? Bring the key to the desk officer. Like how is that going to work to be safe? Then what kind of proof are you going to get from the law enforcement agency if you turn it in? Is there going to be a receipt? Are you going to fill out an affidavit? If you want to turn the guns over to a third party who is not prohibited, what's that process look like? Finally, we think that designating personnel at both the court and any law enforcement agency responsible for collecting guns is really critical. It doesn't have to be that person's sole job, but to have one person responsible for administering, monitoring, and communicating about the process can be a very valuable component in an effective system. Here are some other elements we like to talk about, and there can be very many different flavors of this, but generally speaking, there needs to be a review mechanism, and there needs to be a way to address noncompliance when it's detected. As far as a review mechanism, the one that's used in several places and seems to work quite well is you have direct communication between the court and the law enforcement agency that accepts the guns, so that there can be direct communication about what the deadlines are from the court to the law enforcement agency, and then back to the court were the guns turned in on time? Did all the guns get collected? A hearing should be set, we think, initially, as soon as that order is entered ordering surrender. It can be canceled if proof of compliance is brought into the court. So that hearing doesn't have to happen if it's not necessary, but to set it so that everyone knows by a certain time that respondent's going to have to come to court and show that the guns have been turned in. And the respondent has to have some way of proving compliance, whether, as I said, they fill out an affidavit or they bring a receipt or both. What if there's noncompliance? Well, it depends in part on what your law is, and you may be authorized to do certain things but not another. We obviously work with judges to help them understand their authority to issue a search warrant or an arrest warrant. If guns have been ordered to surrender, there's no proof of surrender by the deadline, and there's enough information around where the guns are and what they are to issue a search warrant. We certainly promote that practice. You could, as a judge, issue a notice to the respondent that you're going to conduct a show cause or a contempt hearing, or order him to court to speak to the guns and where they are and what he's done with them. Or, of course, if it's a criminal violation not to turn in the guns, a prosecutor could have responsibility for charging a violation of the order. That's used in Multnomah County, in Portland, Oregon, and other places as well. A couple of examples of forms that support these kinds of practices. The first is from Oregon, and this is what you would turn in if you're a respondent in a civil protection order case and were ordered to surrender guns. You turn this into the court and you say, I've either surrendered them to law enforcement and here's my receipt. I've given them to a third party, which I've named and described to hold. That person then had signed an affidavit indicating that they're not going to share, they're not going to allow access of the guns to the prohibited respondent or face potential state and federal charges, or you don't have any guns and you do or do not have a concealed handgun license. You turn that into the court. That's the way you establish compliance. In Washington, similarly, Washington State, they developed two forms to be used. One is proof of surrender, which is similar to that first paragraph in Oregon, that you've turned in your guns to a law enforcement agency. In Washington, you can do it to your attorney or to a third party, so that's in there. Or, I didn't surrender my guns because I don't have any guns, and you turn in this declaration of non-surrender in Washington State. In addition, this is an example of a receipt that law enforcement in a county in Wisconsin provides to respondents who have been ordered to turn in their guns, that then would be communicated back to the court, And in some instances, these receipts are faxed or emailed directly to the court, so it can go into the docket, the court record, to establish compliance or noncompliance. So simple but effective tools around monitoring compliance. Finally, I want to show you what Dade County, Florida, Miami-Dade County, has used for many years, which is the court will order the respondent to show cause, hold a contempt hearing if there's no indication that the guns have been turned in. This is the form that they use to order that contempt hearing. It's a mechanism that is a big part of their compliance review process, something that other courts as well can introduce into their processes. So those are examples around firearms. Just a very brief overview. Again, if you have questions, we have projects that are focused specifically on guns and guns in domestic violence cases and guns in CPO cases, and we're happy to provide more examples, connect you with the people who use these forms and processes so they can talk to you about how you can adapt or implement something similar in your own community. Child custody and related relief. What are some suggested practices around enforcing custody or parenting time provisions that are part of civil protection orders? So we're going to start off with a scenario, and I'm going to ask you all to chime in on some responses to the scenario, and then we'll talk about, we'll do a little debrief and talk about some best practices. So in our instance, as part of a protection order that was issued against him, Sam has been given some visitation time with his two children that he has in common with Joan, who is the protected person, the petitioner in this case. The visitation takes place from 5 p.m. on Friday until noon on Sunday every other weekend with Sam. During the two previous visits, Sam returned the kids late. The first time, 45 minutes late. The second time, he ramped it up, and they were an hour and a half late. Currently, he has the kids on a visitation, and Joan just called the police station because Sam has not returned the kids, and it's now way past the time they should be turned in. They should be turned back over to Joan. So I have a couple questions for you about this enforcement scenario around a civil protection order and children. And I'll ask that the poll comes up. Actually, I'm going to go to the next slide, and then we'll pull up the poll. First question is, in your opinion, and you can respond by poll, did Sam violate this parenting time order? that specified some specific visitation times. So glad that people are responding. Means you're still paying attention, which is always good. We can never tell on these webinars. Well, I think everyone thinks he violated it, and clearly he has, you know, the initial violations. Many would say he may have had excuses, and he may have been able to expunge those violations if the court asked him what was going on, whether he was 45 minutes and an hour and a half late. But now that he's significantly later than that, clearly we're looking more at a violation that the court may want to respond to. So we'll ask you to use chat at this stage, if you don't mind, and to please chat in to the chat box that everyone can see what ways you think the court could respond to this particular violation. Any thoughts around that? What do you think would be a creative or effective response to this last violation, which of course is one in a series? A couple of people are typing, so we'll leave it for a second. Supervised exchange. So Deborah Ramirez is suggesting that the parenting time, the restrictions on parenting time be ramped up. Right now there's a schedule, and she's suggesting that perhaps at this stage she may not go to supervised visitation, but supervised or safe exchange, maybe at a program, would be a way to make sure that those exchanges happen when they're supposed to and safely. Thank you. April Scriven, sorry, I don't know how to pronounce your last name, said that stricter visitation or accompanied visitation. So she also wants to ramp up the restrictions around visitation at this stage. I'm sure given the course of conduct, which is increasingly severe violations of the order. Cherie Wise says that he should be admonished at any hearing and required that he adhere to the schedule to purge himself of the contempt. So she's thinking about using a form of civil contempt potentially here, in which she's not ready to ramp up the visitation quite yet, but instead maybe a public admonishment at a hearing, and the court telling him that indeed we are serious about this provision and it's one that's enforceable and it constitutes a violation if you don't follow it. Terrific. All different, potentially effective approaches to this that Sam may or may not respond to. So a couple more people typing. I'll let them finish up and then we'll move on. And you'll notice there's a last question on the slide. What could the system put in practice to enhance safety and promote compliance with the order? I think for purposes of time, rather than have you all chat in, we'll suggest if you can think to yourselves a little bit about what your system either has in place or you think should be put in place around compliance and safety in child-related relief, that would be great. We'll share some ideas that we have. So since it's a violation, the court can monitor his whereabouts via ankle bracelet. May be a possibility. I've not seen that used in the visitation context before, but that's certainly a creative thought. To the extent he wants to continue to have parenting time with his children, would have to agree to that. Set up a stricter schedule in which the exchanges are made in the presence of some responsible person, so a supervised exchange. If Sam still ignores what he's supposed to do, then maybe elevate it to civil contempt. So terrific. All of these are one of the nice things about this is clearly in all of your suggestions is the idea of kind of graduating the sanctions. You're not going to immediately hold them in contempt necessarily. You're not going to immediately say no more visitation. There's no indication in these facts that visitation is unsafe for the children. It may very well be that, like lots of abusers, Sam is using the kids as a way to continue to try to exercise power and control over Joan in this case, and there are ways that the court can try to stop that from happening. So thank you very much for participating in that. And here are some of the thoughts that we have around. I know someone else is typing, and I'll come back to that once she is done. So some of the things to think about in terms of a response to child custody and visitation provisions that are violated is that they first of all, is the fundamental piece that custody and visitation provisions, as I just mentioned, kids are used as tools of continuing abuse, continuing power of control. Those provisions should mean what they say. They should be enforced, not only by courts, but by law enforcement to the extent that they're authorized by state law. In many places they are authorized, even to make arrests for violation of custody and visitation provisions. These are not things that are just sort of dead letters on the order. We spend a lot of time helping people understand that they are sometimes some of the most critical parts of a civil protection order when there are children. Given the impact of DV on children, we know the effects of exposure on children of domestic violence, and this power and control piece is particularly important, as I mentioned. Now, as we said earlier, this is a larger pattern of violation here. There may be other elements of abusive behavior and violations that are co-occurring with this child relief piece. And so to the extent that the judge has a respondent in court, it may be an opportunity to probe other violations that may be going on. It's also an opportunity for the survivor to sit down with an advocate or an attorney if she has one, to talk through these things, and to the extent that there's a hearing around what the abuser has done on the children's side, that those be raised during those hearings to the extent that the survivor wants to do that. So that's an important thing to be thinking about. We think that that showing that the court means business around custody and visitation provisions, and then modifying orders in the ways that were suggested by the folks on this particular webinar, can be a way to send a very strong signal that the system is going to respond to all this, and we care about children's safety. And even though we're not the court that's going to ultimately decide custody long-term, we're not the family court necessarily that's going to do that, this is an important part of this order, and it's something that we're going to be paying attention to. I see that Ms. Palmer mentioned pick up and drop off change to a location with cameras. So that's what is happening at and what time these happen, the exchanges happen, can be captured. Great, thank you so much. What I'm going to do now is talk about a couple more suggested practice, and we'll shift over to compliance review. So we've talked about expediting, contempt, enforcement. We think for custody and related provisions, it's critically important to expedite those because escalation of violations happens quickly. Many of you probably see that in your practice, and courts may see that as well. We think that the graduated sanction approach is very, very effective, and that doing it in open court where others are in the court and watching what's happening when you violate one of these custody provisions sends a very strong message, and that's generally true of compliance hearings, and I think that Judge Anderson will touch on that a little bit as well. We also think it's important, Judge Anderson talked earlier about explaining the options and the processes for enforcement. Please do so to the extent you can as a judge or court staff, as an advocate or attorney working with a survivor, what violations and what the responses to violations of child-related relief looks like in the community. What is law enforcement authorized to do? Are they authorized to pick up kids and make arrests? Are they not? Are they just going to say you need to go to court to do something about it? It's critical for victim parents to understand that. What's the contempt process look like? What do you need to file? What's the form? What do you need to say? And obtaining modification of orders is something that folks should know at the outset. If he violates this order, how do you go about changing the provisions that are being violated and getting a new version of your order? We think all of this should be explained to victim parents at the time of issuance of the order, if possible. I'm going to go ahead and turn it over now to Judge Anderson to close things out by talking about compliance review.
All right, thank you, Darren. So now we're going to talk about why and the how of review hearings. So why should the court hold compliance hearings in protective order cases? Because violations of protective orders are common, probably more common than most people think. As Darren said earlier, a minor violation, what might look like a minor violation can simply be a respondent just trying to test the waters. And if the court does not respond to minor violations, then the violations may become increasingly dangerous. And so to the extent that courts have the resources and the opportunity to respond to violations, then courts should be doing so. Violations should be treated with heightened awareness. It really can be a signal of the respondent's unwillingness to stop abusive behavior and to just tell the court, I don't care what you say, this is a piece of paper, I'll do what I want. And so it's really important to let them know that you're monitoring their actions and that there are consequences for violating the orders. It sends a signal as well to the petitioners that you are going to do everything within the court's power to try to keep victims safe and to hold perpetrators accountable. It is important to set regular compliance reviews. What we do in DeKalb is as soon as the 12-month order is entered, a respondent is given notice of the very next court date. And that next court date is going to be within 3 weeks. And the purpose of that review hearing, that compliance hearing, is to ensure that the firearms have been surrendered, that to also make sure that a respondent has signed up for and begun to complete the state-mandated Family Violence Intervention Program classes. I do want to take a moment to say that, as I said earlier, that these are not cookie-cutter cases. Every case is slightly different, and there are some instances where respondents who are ordered to take, while Georgia law says they have to take the state-mandated Family Violence Intervention classes, if substance abuse or mental illness is an issue or there's some other major challenge, then when we do what we can to make sure that that challenge is identified early, the benefit of having a final order put in place is that the court has the authority to monitor compliance for a full year. So some respondents may find themselves displaced. They don't have a place to live. They don't have a job. They may have a criminal case going on as well as a protective order. And so we were finding that many of the respondents were not taking the state-mandated classes because they didn't have the funds to do so. And so we have a coordinated policy with the Georgia Department of Labor and the DeKalb County Workforce Development Office where respondents are ordered. It's not just a good idea for them to go and look for a job, but they're actually ordered by the court to go and actively seek a job several times a week. And we've had many respondents in our compliance program become gainfully employed and actually better employed than they were before they lost their job as a result of working with the Department of Labor and DeKalb Workforce Development. So it's really important not to take a cookie-cutter approach to this, but to take a look at individuals and meet the respondents where they are. There's some benefits to review hearings. It's accountability for the respondent, and you do it early and often. If there is compliance or set pattern of compliance, then respondents in our program are allowed to attend court less often. They don't have to attend court every 2 weeks. It may be once a month. If they are doing really well with compliance, then they may have to attend court once every 6 weeks or so. So there are some built-in rewards for, if you will, for being compliant. The victims, now while the victims are not, they can come to hearings if they wish, but they're certainly not required to do so. And they're it is very rare for a victim to show up or a petitioner to show up at our compliance hearing. It really is about the judge providing judicial oversight and sending a message to the respondent that the court is watching them and making sure that they are monitoring compliance. If there are any violations, then the court can deal with that at that time. And we believe it's a way of keeping victims safer, that there can be immediate sanctions for noncompliance, or at least we get some explanation to get the respondent in court to tell us why they're not complying. And it's better case management, and the challenges for that can be the time. you know, the courts have to set aside time to have these review hearings on a regular basis. It shouldn't be sporadic. It should be that the defendant knows that every 2 weeks they're going to have to come back to court, or every 4 weeks on a regular basis to stand before the court to give an accounting of what he or she has done or not done and why they haven't done it, and to be told what the consequences of noncompliance are. It's good to have this in an open setting, not to just set the hearings 30 minutes apart as some courts do. I think best practices is to have everyone in the courtroom at once so that those individuals who are there for the first time get to see that the court is serious about compliance, and those individuals who are not in compliance are held in the jury box, and in egregious situations they may be taken into custody. But it sends a message early and often that they have to comply with the court order. The challenges can be, as I said, time to conduct these hearings, resources. We're very fortunate that we do have a designated compliance officer and domestic violence coordinator, and you definitely need support and collaboration from many of your community partners. You need law enforcement collaboration. You need collaboration with advocates. Civil attorneys can be helpful. It's really important to take a look at your jurisdiction to determine what you need. Every jurisdiction has different resources and different needs. There's additional information that you can get online about this from Futures Without Violence at futureswithoutviolence.org about how to keep children safe, families safe, and batterer intervention programs. Strategies for compliance hearings. As I said earlier, you need to set regular compliance reviews. Is it going to be once a week, once every 2 weeks? You need to make sure that you hold them at a regular time. Very quickly, we had an incident where there was a dangerous violation of one of the compliance of one of the protective orders, and the respondent contacted the petitioner, engaged in some dangerous behavior. We used the compliance hearing, his regular compliance hearing, as an opportunity to get him back into court, and he was ultimately arrested. We conducted his review hearing. He was going to his classes, but he was violating the no contact provision, so he was taken into custody for doing that. That took coordination with the court, with law enforcement, and it was an opportunity for everyone in that courtroom to see that all violations are taken seriously by the court. You want to make sure that that appearance is mandated, so you want to give them written notice to appear, and let them know that for petitioners, if they want to come, that it's voluntary. Again, the victim can be involved if they want to, but it really is about the court providing judicial oversight to a respondent, and it's between the respondent and the court. Early in the process, respondents are usually still pretty angry, and so that's a good reason for victims not to be in the courtroom. But after they come to court for a while, they understand that that keeping them on track and making them comply with the order is an opportunity for them to complete the state-mandated classes, finish in a timely manner, and then just kind of move on with their lives. I do want to point out that we have hearings for the weapons being returned. It's not automatic. The court, again, having the benefit of the DV coordinator, we're able to communicate with local agencies and check the database to make sure that there's been no protective order issued against this respondent in some other jurisdiction. It also is an opportunity to check criminal history to make sure that the defendant has not been convicted of, it is prohibited because of a conviction from possessing a firearm. So as a judge, you want to make sure you're not giving firearms back to individuals who are not qualified to own them. The compliance hearings create a standard report. It's good to create standard reporting forms for service providers like the FVIP providers. They check in with the court and submit information on a regular basis about the attendance and participation of respondents. And if there's a problem, they will contact our compliance officer directly about any dangerous statement or dangerous behavior that a respondent has engaged in any of the classes. And so it's a checks and balances system. It's not, we trust that they're attending the classes, but we also want to verify and make sure that they are attending the classes and not having any violations. There are graduated sanctions for noncompliance. You don't always go directly to jail. I think it's important for the judges to develop a rapport, communicate with the respondents, and find out why they're doing what they're doing. The scenario that we had where the respondent was returning the children late, was it intentional? Was it something that was done deliberately? Was there car trouble? Is it something that can be verified? Was he transporting the children on the bus and the bus broke down? Give them an opportunity to explain, but make sure that you hold them accountable at every opportunity. So as we get ready to wrap up, we've got about 4 or 5 minutes here. What will all of you do tomorrow to improve compliance and enforcement of civil protective orders in your jurisdiction? Recognizing that all jurisdictions are different, I would love to see a couple of you respond on the chat space for everyone here. Just tell us what you'll do differently or what you'd like to do tomorrow. Somebody type. All right, Andrew.
In the meantime, I wanted to point out a couple of the resources that we've gathered for you on this last slide. This civil protection order resources. One is the what we call the CPO guide, and it's a comprehensive set of suggested practices and other resources for the various stakeholder groups involved in civil protection order issuance, service, and enforcement. We are in the process of finalizing or getting final approval on a supplement to it for court staff and for folks who work in community supervision, probation, parole folks as well, so that will be coming down the pike soon. We also have this document around custody and visitation and civil protection orders, our guiding principles and suggested practices document, which goes into depth around child-related relief and civil protection orders, what you can do to improve the system. And the the Center for Court Innovation resources that I mentioned earlier and showed, the lethality and risk guides are all available at courtinnovation.org.
All right, so it looks like Andrew Mikovich has said that he'd like to find out how different jurisdictions in his state handle compliance. And he doesn't really know how different jurisdictions react. What I found is that many jurisdictions have criminal compliance hearings, but there aren't too many civil compliance hearings. So just trying to figure out what's out there is a great way to start. You see the resources on the screen here. I'll give you all my information. We are a mentor court, so we have had judges, advocates, attorneys from all over the country come to DeKalb to observe our compliance proceedings, our temporary protective order proceedings. We're available, and I will ask Jennifer if she can just put my information there. I'm happy to answer any phone calls you have, or if you want to come visit, or if you want me to come to your jurisdiction and visit you, I'm happy to do that.
I highly recommend doing it. I've done that visit, and it's really incredibly informative. I also put my email address up on the chat box in case folks had anything they wanted to follow up with me. If I can't answer the question, of course, I'll get you the folks who can. I think we'll just let folks finish up the chat. I think that maybe there's some more contact information coming up. And but we'd really like to thank you for your time and attention today. on this topic. There's a lot more that needs to be thought through around civil protection order issuance and enforcement, but this is at least an overview and somewhere to get started.
Thank you, Darren, and thanks everyone for your time and attention. And again, I would really take advantage of these resources and love to talk to anyone offline, if you'd like, about how to set up a civil compliance calendar. Jennifer? Darren?
Yep. Thanks, everybody. We appreciate your time. We hope you'll have a great day, and please contact us if we can help. Thanks, Judge Anderson.
Take care, everyone.
Thanks, Darren. Take care.
Bye.
Bye.
Thank you.
Bye, everyone.
Bye.
Bye.